Well, hello there, my friend. Welcome. Welcome. I am glad you're here. My name's Gavin. This is my channel. If you're into true crime, you like to whoppa, cut through the fluff and get it through the sensationalism. Just cut on through. That's what we do here. We like to do that. We like to get into the nitty-gritty of cases. And one of the cases that, man, we have been getting into the nitty-gritty of course, is the tragic murder of Madeline Soto. Madeline was a 13-year-old girl. She lived in Kissimmee, Florida with her mom, a couple of roommates, and her mom's on-again, off-again boyfriend, a man named Stephan Stearns. And when Madeline went missing, the police's attention went right to Mr. Stearns, and within just a little while, they had actually charged him with first the SA of Madeline Soto over the course of about 5 years of her short life. 5 years of her short life. She, according to police, was a victim of this man. And then when her body was found, he was charged with her murder. Now, in our last video on this, we read through a motion by the defense through Mr. Stearns' counsel, public defender, fine attorney, that they had made a motion to suppress evidence. And that evidence, the one that we read, was anything related to what was found on the phone, because they argue it was an illegal seizure of the phone. Now, there are actually three motions that the defense put in. Number one is they argue that the illegal seizure of the phone. Number two, they argue the illegal search of the phone. Number three, they argue the illegal search of the Google Drive. They argue that all of those things are fruits of the poisonous tree of the sin by police officers to not properly, basically to not properly get a search warrant in time. I know how that's super simplifying it, and I know that that's not exactly it, but that's basically it, right? They're like, they were given permission to look at the phone for a very narrow thing, look in the settings, see if he's connected to Google, and then they just took the phone. It wasn't until 9.5 hours later, say the defense, that they said, hey, can I have your permission to just go ahead and download the phone? He said it should be fine. Lawyers are like, nay, that does not square with the Fourth Amendment to the U.S. Constitution, nor does it square with the Florida Constitution. Therefore, all of that evidence should be suppressed. It should be thrown out. Today, well, I think the timestamp was yesterday, but I checked last night. It was not there. This morning I checked, and the prosecution has filed their answer on all three. But tonight, what we're going to look at is their response to the defendant's motion to suppress the evidence obtained through the unlawful seizure of the phone. I can tell already I'm going to need lots of water tonight. So this is the one that we're going to look at, because that is we looked at this motion from the defense. This is only a 14-page document, so it's not like we're not going to be here for hours, guys. Keep in mind that I do want to read your comments, and so if you put GF in your comment, no spaces, just GF all together, that will help me on my end to be able to see your comment, okay? Now, I believe, let's see who this is signed by real quick. This is signed by the assistant state attorney in the state of Florida, what we call district attorneys. In most jurisdictions, they call state's attorneys or state attorneys in Florida. So this is the assistant state attorney who is prosecuting the case, Danielle Pinnell. Okay, let's dive right on in, shall we? Unless we've got a couple comments that we should. Let me just check real quick. Haley, Let's see. Haley was like, hey, wait a minute. What the devil? Come in a few minutes late and they find out they screwed up the search and seizure. No. Yeah, that was the defense's argument. And I have to say, I thought it was a compelling argument. Being a non-lawyer, being somebody who does not debate or argue for a living, it seemed like a compelling argument. Now, a lot of the comments on the in the live chat and then the comments later on my last video, people disagreed with me. And I think that's terrific. Disagree away. That is a good thing to do. All right. So we're just going to see what the prosecution has to say, shall we? Let's get on in there. Here we go. State's response to defendant's motion to suppress evidence obtained from unlawful seizure of cell phone comes down to the state of Florida by and through the undersigned assistant state attorney, and hereby states as follows. The defendant was arrested. Oh, dude, I need to get rid of this mouse. It gets like, the buttons get stuck. And it's an old, like, wired, corded, like, Microsoft mouse from, it feels like about 1998. It's about time to let go, Gavin. It squeaks. It does weird things. All right. The defendant was arrested pursuant to an arrest warrant in the above-styled case on February 29th, 2024. On March 11th, 2024, the state filed an information charging the defendant with 8 counts of SB on a child under 12, 5 counts of SB on a child 12 to 18, familial custodial authority, 7 counts of L&L, and so on and so forth, 40 counts of unlawful possession of CSAM. Okay. And each count is 10 or more images, all right? It's crazy. So, and I'm sorry I have to do this YouTube language, but you guys get it. And we are talking about the case, the SA case, or technically it's the SB case, right? I'm not talking about the murder case here. Okay, the state provided discovery to the defense on March 20th, 2024. I mean, that's not bad. That's pretty quick. And discovery has been ongoing. On February 6th, 2025, by the way, I'm sure you guys all know, but for those of you who don't, you don't need to feel like, you're uninformed or anything, but that is the way it works in the United States. As the prosecution is gathering evidence, they must turn all that evidence over, including exculpatory evidence, and that is known as discovery. The defense has the right to be able to mount a good and thorough defense, and in order to do that, they need access to the information, right? So it's not like the TV shows where they, throw in these surprises throughout the testimony of the trial. It really hardly ever happens that way because the defense is entitled to discovery. Okay, on February 6th, 2025, the defense filed defense motion to suppress evidence obtained from unlawful seizure of cell phone. The motion alleged violations of the Fourth Amendment to the U.S. Constitution and Article 1, Section 12 of the Florida Constitution. By the way, I haven't pre-read this. I want to be able to comment on it and react to it as if I've never read it before, so that's why I do it this way. Statement of facts. I don't know why they are redacting things. We know who the victim is, but we're gonna assume we know what's underneath these redactions. Okay. Okay. On February 26, 2024, Madeline Soto was reported missing to the Orange County Sheriff's Office by her family. The family contacted law enforcement at approximately 4:30 p.m. There were 3 calls made to the Orange County Sheriff's Office prior to deputies arriving. At approximately 7:35 p.m., Deputy Frankie Joseph with the Orange County Sheriff's Office made contact with Jennifer Soto. Let's bring up Jennifer Soto's picture here. The defendant, Mr. Stearns, and members of Ms. Soto's family. All individuals were present in the lobby of the business building in which Ms. Jennifer Soto's mother worked. Deputy Joseph inquired as to the identifying information for Madeline from Ms. Soto and the family. The defendant stated he had dropped Madeline off for school that morning. He described Maddie to have been wearing a green hoodie, white Crocs, and either blue or black pants. Deputy Joseph was also told that Maddie had not taken her cell phone to school that day and only had her school computer. At approximately 7:47 p.m., Jennifer Soto provided Madeline's phone to law enforcement for review. Sworn written statements were collected from the defendant and Jennifer Soto on February 26, 2024. The defendant's sworn statement states as follows, and yeah, we've gone through all that. And then Jennifer Soto said this, okay, we know the story. The story is he said he took her to school, was going early to go buy McDonald's. She slept in the car. She didn't want to go to McDonald's, which, I mean, ding, like red flag right there. Number two, she didn't want to be dropped off in front of the school because his car was a hoopty. Okay. But anyway, and then Jennifer said that she went to pick her up, couldn't find her. Okay. At approximately 9:05 p.m., and I'm not yada-yadaing that for any particular reason. I mean, we just know it all. I don't believe any of it. It's just very hard to believe anything they say. Of course, what they say can be used against them, so it's important to have that in here, but I'm yadaing through it, okay? At approximately 9:05 p.m., while accompanied by law enforcement, the defendant drove his vehicle to the area he claimed to have dropped Maddie off for school at. The defendant stopped in the middle of the roadway, got out of his vehicle. During this time, law enforcement provided the defendant with Madeline's cell phone. The defendant claimed they were standing in the area in which he last saw Madeline. Deputy Joseph made contact with a church in that area and went through surveillance video. They thought that they saw someone, but didn't turn out to be Maddie for obvious reasons. She was long dead and already just disrespectfully and unlovingly discarded. At approximately 12:30 a.m., Officer Tristan Clark arrived at the home of Jennifer Soto and was greeted by Miss Soto and the defendant. Law enforcement was actively searching for Madeline and was unsuccessful. By all accounts, the defendant was the last person to have seen Madeline on February 26th of last year. On February 27th at noon, Detective Francis Hunt with the Orange County Sheriff's Office conducted an audio-recorded interview of the defendant. We have listened to that here on this program. Detective Hunt swore the defendant in prior to asking him questions. The defendant reiterated that the last time he saw Madeline was when he dropped her off for school the day prior. During his interview, the defendant told Detective Hunt that he did not recall the exact time of the drop-off because he left his phone at home. It was also during this interview, again, red flag, but ding, nobody does that. Like, we can make mistakes, for sure, but as those mistakes, those out-of-the-ordinary events start to pile up, as pointed out by Chris Stearns, actually, it starts to be one big giant red flag, right? It was also during this interview that the defendant stated that Madeline slept alone with him in the upstairs bedroom so Jen could get better sleep. Oh my goodness, I bet the alarm bells were going off inside these deputies' minds. The defendant also told Detective Hunt that Madeline left her phone at the residence as well when they left for school. At approximately 7:16 p.m., an audio-recorded interview with the defendant was conducted by Detectives Myra Tagler and Luisa Costa. The interview occurred at 4012 Santa Maria Drive, the Soto residence. The defendant was not in handcuffs and was free to leave. The two detectives who interviewed the defendant were in plain clothes. The defendant stated that he and Madeline left the home between 7:30 and 7:45 a.m. The defendant again reiterated that he dropped Madeline off a little way from the school the day prior. The defendant detailed their route on the way to drop her off. The defendant indicated that he tried to go to McDonald's, at a certain intersection. However, he did not stop at McDonald's. The defendant estimated that he dropped Madeline at approximately 8:20 to 8:40 a.m. At approximately 7:37 p.m., after the defendant relayed all this information, the following exchange occurred between Detective Tagler and the defendant. Detective Tagler, do you mind if I look at your maps real quick? Defendant, yeah, that's fine. Detective Tagler, thanks. Okay, so they're starting to hone in on the defense's claim that he only gave the detectives permission for one little thing, which was the settings to see if Google was connected to the phone, right? We can see here that nope, we've got a little hole, and that hole is, can I look at your maps? And the answer was yes. The defendant unlocked his cell phone and handed it to Detective Tagler. There's some more clarification with Detective Acosta on the route the defendant took to reach the school and the location of where he claimed to have dropped Madeline off. Then Detective Tagler has the following conversation with the defendant. Do you mind if I just take a picture of your history? Defendant, yeah, that's fine. Another, just chipping away at the argument. The defendant and Detective Acosta discussed what time the classes began at Hunters Creek Middle School. Their conversation continued. Detective Tagler, what kind of phone is this? S23 Ultra, I think. I don't know how to work this thing. I'm sorry, I barely know how to work it myself. I'm an iPhone person. Oh. Is it okay if I go in your settings real quick? I just want to see if you're logged onto your Google. Stern says, I'm not logged onto my Google with that, actually. Is it okay if I check? Yeah. Okay, now this is the part of the conversation that the defense focused in on. There was some further discussion between Detective Acosta and the defendant regarding the type of digital devices Madeline had and where she kept them. Detective Tagler then had the following conversation with the defendant. Hold on, I don't know how to use this phone. Sorry, I don't mean to interrupt. A brief conversation occurs about Maddie's behavior. Then the detective again. Is this what you use to go places? Yes, go places, search addresses, look at store hours, write reviews. It's a pretty new phone, though. When did you come back to help Jen? Is that her name? What do you mean? Because you live down south. When did you come back up north to help her? I just got here this weekend. Do you remember what day it was? Sunday. Sunday was her birthday party. So yeah, it was the evening after her birthday party, Sunday. Okay, do you remember what time you got here on Sunday? 8:30ish maybe. Okay. Just in time to make sure that she was doing all her nighttime routines, waiting for her mom to get home. You live in Northport, right? Yeah, I split my time between the two places. Is that on Snug Street? Yeah, that makes sense. You have a lot of Snug Street on here. Yeah, I split my time between the two. Detective Acosta inquired as to whether the defendant and Jennifer Soto went anywhere to look for Maddie Soto, I guess, the night before, February 26th. The defendant denied knowing whether they went to look for Maddie anywhere because he had taken Ativan the night before because he had been so worried. Okay. So far, though, I mean, I guess they're going to argue tacit approval. Like, he's letting them look through the phone and he's having a conversation with them, I guess is the argument. So far, there are only two where he specifically said, yes, you can look at my maps, my places, and then, yeah, you can look at my settings. But, okay, let's keep reading. And by the way, they argued that he was on a prescription drug at that time. The defense argued that, and the prosecution brought that up. Okay, Detective Acosta then went through the details of the directions for the route that the defendant claimed to have driven to take Madeline to school. The defendant then went through this discussion again, but this time included time frames. Detective Acosta then indicated that the defendant's vehicle was not where he indicated that he was, according to the traffic cameras in the area. Yeah, guys, everybody knows this, right? Because we're brilliant non-criminals. You and me, we are smart, not stupid, non-criminals, right? When the police are asking questions like this, they kind of know the answers, or they at least know whether you're lying or not. They already have evidence. I mean, it's the day after. They've had 24 hours to investigate. What he should have just said is, lawyer, I'm glad he didn't. Okay. The defendant then indicated that he went back home because he forgot his gate clicker. At 7:53 p.m., Detective Tagler handed the defendant his phone back. Immediately after handing the defendant his phone back, Detective Tagler stepped away from the defendant. Detective Acosta stayed with the defendant and they continued speaking. At 7:57, so 4 minutes later, Tagler returned and had the following interaction with the defendant. She says, "Can you unlock this one more time, please?" "Sure. I have a question." "Yep. Sorry, are you guys done? The other detective mentioned that you did not have your phone yesterday." "Correct. Tell me about that." "I left my phone home in the morning, too. I was so busy riding her, or Madeline, to get us out the door on time that I left my phone." Was that a Freudian slip? I'm sorry to be gross. I hadn't catch that. I was so busy riding her. Is that a... I guess that is a way of like saying that you're trying to push your your child to do something, recognizing Madeline is not his child. But anyway, she left her phone. We both left our phones. Okay. "Did you have your phone when you went to the smoke shop?" "Not the first time after I dropped her off. I was still without it. I got my phone, and went back to the smoke shop." "Okay. Later when I got home." "Okay. I also noticed I was checking your call history. I noticed that you don't have anything before this morning. Is that usual? On your phone?" "No, it's a new phone. Stupid. I went to do an update yesterday morning. I don't know what the F. Pardon me. I don't know what the heck I did. But somehow during the massive OS update, I managed to factory reset my phone and lose all of my contacts, all my information." "Uh-huh. What time was that? Do you remember?" "Oh, sometime while I was hanging out with Jen. Jen might know. I looked at her and I said, 'What did I just do?'" "Okay. She might know better. I don't know what time it was. It was when I was here with Jen." "Okay, I don't think I have any other questions." Again, ding, you reset your phone. At approximately 7:59 p.m., Tagler advised the defendant that law enforcement was going to hold onto the defendant's phone. The defendant was told that he would receive it back when we are done. It was at this point that the defendant's phone was seized by law enforcement pursuant to this investigation. So, hold on. So he must have handed over the phone during this conversation. Okay. So that's 7:59 p.m. I can't remember what the defense said. On February 28, 2024, at approximately 12:16 a.m., Tagler and Acosta conducted a second audio recorded interview of the defendant. During the beginning portion of the interview, Detective Tagler advised that law enforcement had been going through Madeline's cell phone and noticed a lot of conversations between her and the defendant. Detective Tagler asked the defendant to advise as to what type of relationship he has with Madeline. The defendant then stated, "She thought of me as a dad, thinks of me as a dad." Uh-huh. Thought of me as a dad. Uh-huh. Yep. Less than a minute into the conversation, Detective Tagler has the following exchange with the defendant. And hang on just one second. I want to do the math here. So 12:16 a.m., 7:59 p.m. So really we're talking about 4 hours and 17 minutes is what the prosecution is arguing. Okay, I'm sorry. I don't mean to cut... Oh, no. Hold on. We did this. No. We didn't. Okay. So less than a minute into the conversation, Detective Tagler has the following exchange with the defendant. "I'm sorry. I don't mean to cut you off. Your phone. I told you that I was going to hold on to it and that we would like to download your phone, right?" "Okay. Is that something I have your consent to do, or do I need to get a search warrant for your phone?" It should be fine," he says. Okay, so that is permission. I don't think that she said anything about downloading the phone before, but okay. "You're okay with us going through your phone?" "Yeah." "Okay, can I have the PIN to your phone?" 42586. 42586. Okay, perfect. Thank you so much. All right, so that's our background information. Let's pause here. Let's bring up Miss Maddie, and let's take a look at your comments, okay? I want to get this refreshed. We're just going to... Let's see. Tracy asking, has the judge ruled on any of this? No, not yet. In fact, on the 23rd of this month, what are we at? So 2 weeks from today, there will be oral arguments here. Okay. Cindy says, how the heck did they screw this up? I think they were desperately looking for a missing girl. I mean, if it is a screw up, if the judge comes down on the side of the defense, it's major, man. It's major. And I already told you guys about the case here in Western Pennsylvania from the 70s where the dude full on got off from murdering a woman because they hadn't read him his Miranda rights. So this sort of thing happens. And we want... That's the thing, is that we want integrity in the law, integrity and fidelity in the law. We want police to not infringe on our rights. We want them to follow the law as established by statute, as established by precedent and case law, right? But yeah, it's possible for screw-ups to happen, for sure. Emily 53, why does law enforcement keep making the same mistakes? Don't they have training on how to legally obtain evidence? What is the problem? Yeah, I think it comes down to human error. I really do. I think it just comes down to they're human. They make mistakes. And yeah, super chiasmatic. Gavin Squeaky Mouse. I mean, that seems kind of inappropriate to me. Yeah, it doesn't do it on demand. I'm trying to... But it squeaks every once in a while. Ugh. Does it have a ball instead? No, it has a laser. It's post ball. This thing is old though, guys. Like I get so set in my ways. It's so comfortable. I like the cord. I just like it being plugged in. But okay, I need to stop. Okay. Gavin, what about the hard thumb drives his parents turned over? Yeah, this has nothing to do with this motion. This is all about the phone. Does anyone know if Stephan has a brother? Yes, we understand he does have a brother. Okay. Oh, did you hear it? The squeak. Yeah, they have to redact her name because she's a minor. I think that's their state law. Yeah, they probably do. The defense doesn't do it, but okay. Miss Connie. Gavin, I think I remember during the Jen Soto interrogation, it sounded like she was the one who pushed him into giving the phone without a search warrant. Yeah, maybe that was her memory of it. I mean, maybe that's why he accidentally restored the phone twice. He's like, yeah, there. I need to not come off as super suspicious. No, dude, you already are suspicious. Come on. Okay, keep going real quick. Oh yeah, Colleen. No kids pass up McDee's. No. Hand of Ike, their behavior in the lobby, watching that, I knew they were guilty. They both were guilty. Jen is just covering for Stephan Stern so much. So many lies. Zach likes my yada yada. Okay, good deal. Good to know, Zach. I do yada yada things. Okay, just a couple more before we move on to the legal argument here. Let's see. Carol, welcome. Glad you caught alive. Jess, 1, they did not know his phone password, so how could they check his phone when they took it? 2, if he mentioned he factory reset, wouldn't you want to hold onto it until you have a warrant? Yeah, I mean, they ultimately did get a warrant. They should have gotten a warrant anyway. I don't know why police make that Well, I do know why. Or at least I suspect I know why. Why they go, are you going to just let me do this or do I have to get a warrant? They want to know what your response is. They have to get a warrant. It won't hold up in court if they don't. Even if there are exigent circumstances, even if there's probable cause, prosecutors want them to get a warrant. And so they always do. And it's easy to get. There's always an on-call judge in every jurisdiction in the county. I wouldn't call him a friend, but I would say an acquaintance, somebody I'm friendly with, who up until a year ago was a magistrate judge, and he was on call pretty frequently. So yeah, they should have just done that. Can't JS press charges against him? Wouldn't that get him in front of the judicial system for SA and CSAM? Well, she could. There are already charges. I don't understand, anatomy scholar. I don't understand why she would do that. I mean, she might be able to do some kind of civil something after the fact to go after his estate for some civil penalty. KC32, Gavin, once SS gave them his passcode, that should be open evidence. Can't pick and choose what part. What if his screensaver was gross? Oh, can't look at that. Only settings. So the Supreme Court disagrees with you on that. At least my interpretation of it. The Supreme Court looks at it very clearly that the what is it that it's called, the plain view doctrine applies. Like if say you give me your password and it opens to a screen that is in plain view, I should be able to enter that into evidence for sure. However, as soon as I move to another screen, the Supreme Court's like, no, that's like going into a room that you don't have permission to be in. So that's why I think the defense's motion is compelling. I mean, the defense and the prosecution disagree on the chain of events that led up to the phone being seized, for sure. But I still think the defense has a leg to stand on here. And by the way, if the defense loses this motion, this will be a huge, pillar of his appeal later on if he were to get convicted. All right. Super charismatic. Gavin, I'm really not looking forward to hearing the text conversations he had with Maddie when the trials comes. Yeah. Jess says, yeah, not 9 hours. Yep. Okay. So let's pause there. All right. We're going to go on back over here. Let me bring up, one of these days, I'm going to have 3 monitors. It's going to be glorious. Okay. Consensual search of cell phone during interview on February 27th, 2024. Warrantless searches are per se unreasonable pursuant to the 4th and 14th Amendments unless there is a recognized exception to the warrant requirement. Consent is a recognized exemption of the warrant requirement. The standard for measuring the scope of the consent given under the 4th Amendment is objective reasonableness. The state has the burden of showing by clear and convincing evidence that the defendant's consent to search was freely and voluntarily given. For a search to be deemed involuntary, the court must find that the defendant's will was overborne and his capacity for self-determination critically impaired. I think that's the reason why the defense put in the whole Ativan thing. By the way, objective reasonableness, recognize exemption. Okay. Detective Tagler conducted an interview of the defendant on February 27th. The interview began at 7:16 and lasted approximately 44 minutes and 24 seconds. Present during the interview was the defendant, Tagler Acosta. The interview occurred outside the residence, which had been secured pending a search warrant at the time. The defendant was not in custody or handcuffs. During this interview, the defendant gave consent for Tagler to view different things on his cell phone. The defendant's cell phone was password protected. I don't know that he did give consent, though. If she, or if Detective Tagler, now I can't remember if it's he or she, but had the phone, I think it's her, it's Myra, doesn't matter, had the phone and was going through things and then saying, hey, this is your maps, right? This is your blah, blah, blah. I don't know that that is consent. I think it is like, I guarantee you that the prosecution behind the scenes is going, come on, guys, why did you do this? Why are we even talking about this? Had you just done it the proper way, we would not have to go through this. But they're making a calm argument here. Anyway, the defendant's cell phone was password protected. During the interview, the defendant entered the password to unlock his phone and provided it to Detective Tagler. Tagler specifically requested permission, which the defendant freely gave, to explore maps, history settings, and to determine whether a Google account was attached. Okay. But not to actually look at the Google account, right? The defendant was present during the time that Tagler was viewing his cell phone content. At no point did the defendant attempt to withdraw the consent that he had given Tagler. Later on in the interview, the defendant unlocked the phone a second time. This interaction between Tagler and the defendant was consensual, and any information that Tagler observed during this interaction was lawfully obtained. I don't think so. Like, I don't buy that argument. I'm not a lawyer, though, so it's fine. I'm just, I might say he gave consent to look at maps, history, and settings and to determine whether a Google account was attached. But he didn't give consent to just look through the phone. And I know that is a distinction with a difference, guys. That's a very important distinction. Okay, seizure of the cell phone. The defense heavily relies on US v. Place in support of their argument that the seizure of the defendant's phone was unconstitutional. In Place, the court was faced with whether the Fourth Amendment prohibits law enforcement from temporarily detaining personal property on the basis of reasonable suspicion. Law enforcement in Place detained the defendant's luggage for the purpose of a sniff test by a trained narcotics detection dog. The dog was utilized approximately 90 minutes after the initial detention and alerted to the presence of narcotics. Law enforcement obtained a search warrant 3 days later. The court's analysis was based upon a seizure pursuant to reasonable suspicion. In determining whether the detention was permissible, the court must weigh the intrusiveness of a limited seizure of the individual against society's interest in detection and prevention of crime. The court also identified factors that the trial courts should consider when making the determination. 1, the duration of the detention. 2, its intrusiveness or degree to which a person's possessory interests are interfered with. 3, the diligence with which officers pursued their investigation, seeking a warrant promptly and communicating with the suspect about the specifics of the detention. And 4, the government interest or law enforcement purposes served by the detention. This is the analysis when the detention is based upon reasonable suspicion alone. The court in Place also stated, where law enforcement authorities have probable cause to believe that a container holds contraband or evidence of a crime, but have not secured a warrant, the court has interpreted the amendment to permit seizure of the property pending issuance of a warrant to examine its contents if the exigencies of the circumstances demand it or some other recognized exemption to the warrant requirement is present. Of course, the defense argued, well, he had already reset his phone. There's no exigency here. Blah, 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 blah. Case law. In the instant case, the item seized by law enforcement was the defendant's cell phone. The Supreme Court has interpreted the Fourth Amendment to allow a warrantless seizure when law enforcement can show both 1, probable cause to believe the property contains contraband or evidence of a crime, and 2, an applicable warrant exception such as exigent circumstances exist. That's US v. Babcock. Again, the defense argued that there were no exigent circumstances, and there had been no probable cause to believe that there was anything on the phone because it had been reset, factory restored. That was their argument. Okay, probable cause to seize the defendant's phone. The first prong in the analysis for the court is to determine whether Tagler had probable cause at the time that the defendant's cell phone was seized. The seizure of the cell phone occurred approximately 8 p.m. Probable cause merely requires that the facts available to the officer would warrant a person of reasonable caution to believe that certain items may be useful as evidence of a crime. It does not demand any showing that such a belief be correct or more likely true than false. And that is important. It doesn't matter if they're right or wrong. Basically, do the facts support the idea that a reasonable person would believe that there is probable cause there, that there might be evidence of a crime there, whether or not it's true. A practical, non-technical probability that incriminating evidence is involved is all that is required. Probable cause only requires a substantial chance that there is evidence of criminal activity. The courts have also found that a substantial chance exists where the facts within the collective knowledge of law enforcement officials suffice to cause a person of reasonable caution to believe that a criminal offense has been or is being committed, and that evidence of that offense will be found in a particular place. Detective Tagler and members of law enforcement had probable cause to believe that there was evidence of a crime contained in the defendant's phone at the time of seizure. Again, I don't know that that's going to hold up, considering the defense saying the phone was factory reset. There's after the crime. They would then argue a person of reasonable caution would not believe that probable cause exists, right? At the time of seizure, the following information was known to law enforcement. 1. Madeline Soto, a 13-year-old child, had been missing for over 24 hours. 2. The defendant was consistently identified as the last person to have seen Madeline prior to her disappearance. 3. Law enforcement had tag reader evidence that the defendant was not being truthful with regard to his movements on the 26th, including when and where the defendant claimed to drop Madeline off at school. 4. Madeline never arrived to school on the 26th. 5. The defendant factory reset his phone on February 26th. 6. The defendant was alone with Madeline in a bedroom the night prior to Madeline's disappearance. 7. The defendant regularly utilized his cell phone to speak with the defendant. To speak with Madeline. 8. The defendant, when confronted with inconsistencies which evolved in his statements, began adding additional explanations. 9. The defendant had his cell phone with him during a portion of the day on February 26th. 10. The defendant regularly used the location data and internet on his phone. And 11. The defendant's phone was attached to the defendant's Google account, even though the defendant denied being logged in. Collectively, these circumstances gave law enforcement probable cause to believe that the defendant had committed a crime against Madeline and that the evidence of the crime would be found on the defendant's cell phone. I cannot argue. That is a good position to take. And by the way, I want the prosecution to prevail here, but only if it keeps the fidelity of the law intact, right? The law must remain integral. All right, we're almost done. Exigent circumstances. The 4th District of Appeal in State v. Darter cited to the Supreme Court when considering exigent circumstances, the test of whether exigent circumstances exist is an objective one. Whether exigent circumstances exist in a given case is a fact-specific inquiry that depends on the totality of the circumstances. When considering the exigent circumstance of imminent destruction of evidence, the objective test applied by the courts is as follows. The government must show more than a subjective fear of imminent destruction of evidence. The fear must be objectively reasonable. In determining whether the agents reasonably feared imminent destruction of the evidence, the appropriate inquiry is whether the facts as they appeared at the moment of entry would lead a reasonable, experienced agent to believe that evidence might be destroyed before a warrant could be secured. In other words, were the police unreasonable in not getting a warrant in the circumstances confronting them? Of course, again, the defense is saying no exigency. He had already factory reset his phone twice. Therefore, the evidence that you are afraid might be destroyed has already been destroyed. I mean, I'm paraphrasing, of course. Courts have found the exigent circumstances exception particularly compelling in cases dealing with electronic files. In Bradley, the court found exigent circumstances permitting law enforcement to shut down servers in order to prevent employees from destroying evidence. Detective Tagler, along with other detectives of the Orange County Sheriff's Office, had an objective fear of the imminent destruction of the evidence contained on the defendant's phone. The defendant had been evasive and deceptive in law enforcement interviews and was untruthful regarding his whereabouts on the morning of Madeline's disappearance. The defendant had already attempted to destroy evidence contained on his cell phone by factory resetting the phone at some point during the late morning hours of February 26th. Although the cell phone had been factory reset, there were still exigent circumstances supported by an objective fear of further destruction of evidence by the defendant. Okay, that's how they're addressing that. The defendant was also aware that law enforcement was interested in determining the Google account associated with the phone. The defendant was aware at that point that law enforcement had evidence that contradicted his claimed movements on February 26th. It is reasonable to believe that the defendant knew he was under suspicion once Tagler and Acosta confronted him with inconsistencies and showed interest in the information contained on his cell phone. It is also reasonable to conclude that the defendant had the ability and incentive after the interview with Tagler and Acosta on February 27th to further destroy incriminating evidence contained on his phone. I mean, it's an argument. I think that the defense's argument about that is a little more compelling. It was to his belief, it was already destroyed. Conclusion. Law enforcement legally seized the defendant's phone on February 27th after developing probable cause that there was evidence of criminal activity contained on the defendant's cell phone, and exigent circumstances existed that the defendant would further attempt to destroy evidence contained on the cell phone. Therefore, the defendant's motion seeking to suppress evidence recovered from the seizure of the cell phone should be denied. And then there is the signature. All right, let's bring Maddie up again and bring up comments. All right, get this refreshed a little bit. I'm just going to go, not going to be able to get everything here, guys. Kimberly says, Gavin loophole, he gave verbal consent. Hi, by the way, sorry I'm late to the party. Love you show. Love that you're here. I think the defense's argument that the consent that he gave was limited in scope is a reasonable argument. It's compelling. Let's see. They're trying to use fruit of the poisonous tree to get Brian Koberger in the Idaho 4 case off too right now. Yeah, I mean, because it's a very important piece of our law. Very, very important. I mean, it goes back to the founding of the nation. Our founding fathers and mothers knew that King George and all the sovereigns before him, and likely all the sovereigns after him, would continue to unreasonably seize and unreasonably search property of the colonials. And they didn't want that for the new nation, and we need to hang on to that, right? So I don't mind that they go through this process. What I mind is that police should, I mean, Detective Tagler could have very easily at the very beginning, hey, I'd really like to look through your phone. Is that okay with you? Done. Then it's done. Then the consent is there. I'd like to look through your phone. Is that okay? And then maybe talk through, I'm going to go to settings first. Is that all right? Yeah, okay. But you're okay if I look through it, right? Yeah, okay. Like that would have covered everything. She didn't do that. I feel Stearns will somehow weasel out of this, says Sonny. He seems like he thinks he's so clever, and in a way, I think he has a mindset that he's still a young buck and good looking. Okay. Yeah. Tyler says, Gavin, we want our rights when they are violated, but we don't care whose are taken away when we are violated by predators. It's a tough row to hoe. Yeah. That is the thing, is that we always have to keep in mind that if somebody else's rights are taken away, that opens the door for our rights to be taken away. Therefore, everybody's rights should be protected, even the worst among us. They asked Stephan Stearns, do we need a search warrant? They did. They did. Of course, the defense's argument was that was long after it had already been illegally seized. Remember, we're not talking about the search in this one. We're talking about the seizure of the phone. All right. Hugging demons. Them demon huggers. Is this a new demon hugger? Or is it the same demon hugger that is hugging demons? I don't know. No shame on the mouse's tail. I still have one too. Yeah, I like the chords, man. I like the chords. Andra Salis says, and I'm sorry if I just butchered your name, law enforcement could have feasibly looked at his phone to see map info. I will often go to maps and take a screenshot. Yeah, they could have. Patricia in New York City. New York City. Florida State Supreme Court has upheld that giving a password is consent to search. I'll have to look at the other, like, there are another couple responses to the defense's motions. This one is about the seizure, not the search. But another one is about the search, and we'll have to see what the state of Florida through the state attorney argues. Maybe they argue that. I don't know. I don't know that case law, Patricia. I take you at your word, but it'll be interesting to see if the state attorney argues that. Bruno Orante. I feel like I'm just murdering names tonight. I watched the interview with Stephan's parents. What I got out of that was that he was and is a professional liar and gaslighter who was able to spin any story for self-gain. Yeah, but keep in mind that these motions are not by Mr. Stearns. They're by his lawyers. But I agree with you. Wouldn't a missing child be probable cause? No, not in and of itself. I don't think so. No, I think the probable cause has to be that a reasonable person would say to themselves, evidence of this missing child is on this phone, but you have to be able to articulate what that evidence would be. It's tough. Super charismatic. Jennifer Soto could go after his estate of Warhammer figurines and other toys. Don't forget the purple dragon with the watch inside. Zach says, if the motion is granted, I can't imagine it would really hurt the state's case. There is much other evidence that would have been discovered separately through the MWIDA investigation. Yeah. I mean, yeah. I'm trying to think. The thumbnail drive could lead a reasonable detective to say, is he sharing that? Let's check his Google Drive. They may have gotten there anyway. Gavin, I now need to cut back on my dose. Initially, I got worse. Now I'm showing up late. Stephanie says exigent circumstances are the legal standing that will allow the Google Drive images in. They were looking for a missing girl. Yeah. I mean, I'm sorry, but I don't see the connection though. I mean, yes, they were definitely looking for a missing girl. But what exigency would lead you to believe that they would find her on a Google server? I'm arguing for the sake of argument, I'm not arguing for the defense here. I'm just arguing for the sake of kind of thinking these kinds of things through, right? Kate in Virginia. Kate, my wife lived in Virginia, and I know a little bit about it. It doesn't matter. My daughter went to college in Virginia. I've spent a fair amount of time, not tons, in the great state of Virginia. Anyway, I think the argument that law enforcement would find those photos anyway is the best one. They did get a warrant ultimately, and that would have happened even if they hadn't looked beforehand. I think you're probably right there. Yes. But in exigent circumstances, you would open every door inside the house. Yes, that is true. That is true. So, for example, say Madeline, they're looking for a missing child, and they're like, let's check the house first because she might be somewhere in the house. That exigency could exist, right? Look through the house, every door, open every cupboard, every container, the whole thing, right? That a child could be in. Yes. But does that translate to a phone? The defense says no. And the prosecution says, yeah, there was exigencies because of all these things, these 11 things that we just mentioned, right? Great comments, guys. Dang it, we're coming up on the hour. Tara says, Gavin, can we go through your phone? I'm sure that's fine. Sounds like consent to me. Then she asked for his password. Yes, but we're not talking about the search of the phone. We're talking about the seizure of the phone here. And everything that comes after that is fruit of the poisonous tree. That's why they start with the seizure. It's an important distinction. Andrea Salis says, he gave his password. It was his birthday. People actually do that. Guys, don't do that. Don't make it like part of your social security number. Don't make it your birthday. Don't make it at your anniversary. Make it something else, okay? Yeah, I saw your comment before, Patricia. Kate and VA, same thing. Password is consent, but that's the search, not the seizure. All right. I'm sorry. I'm going to skip down. We're going to run out of time here. Tamara says, let's meet my wife. You know, if you want to meet my wife, you can go to my website. Oh, what a great segue there. If you want to meet my wife, go to my website, okay? Then click on cases. You will see a list of all the cases that I have documents on, okay? Scroll on down to Ellen Greenberg. Boom, right there, okay? And then once you've met Ellen Greenberg, you will meet my wife in this video right here, the second video I did on Ellen Greenberg. My wife is actually a pretty shy person, and the fact she did this for me in the first place is an indication that she loves me beyond what she should. She does not like the camera, and I don't blame her. You know, some people just aren't comfortable doing it. While you're at my website, remember that you can contact me by clicking this button. You can click this button to go over to the fish tank and join us on Facebook if you're there. If you see this little thing right there, that's an indication that I have nothing in my shopping cart, and the merch store has lots of fun stuff, including the Cluvelta collection. Guys, these are the things that are selling the most right now. And I deeply appreciate you buying merch. Every time you buy a mug, I get like $4. And I love it. It's just amazing. The Dill Hole collection is also doing particularly well. It's just been a t-shirt and mug kind of a thing so far. But there are lots of good ones. Lots of good ones in there. If you just want to be simple, we've got my logo stuff. Really, really easy. Anyway, that's the merch store. And I appreciate you guys taking care of me. I really appreciate all of you who support me on Patreon too. Makes it very, very well. It makes it possible for me to run the website. That Patreon pays for my website, and it's appreciated, man, because it is chock full of stuff. Hey, this button will take you over to Crime Cod, my second website, which is a true crime news site. I invite you to subscribe to the newsletter. It'll pop up the first time you go over there. Anyway, that's enough of the shameless self-promotion. Guys, what are we going to do? What are we going to do? We're going to be back tomorrow, 7:30 p.m. Eastern. It might be this case. It might be another. But we're going to dig into more documents. There are more documents to dig into in the Madeline Soto case, and I'm all about it. As long as you guys are about it, I will continue to be about it. But I'm not quite sure what we'll dig into tomorrow, but we will be here 7:30 p.m. Eastern time, as always, to cut through fluff, cut through sensationalism, and do so having a good time. Not taking ourselves seriously, but taking the cases seriously, because we've got some victims here that we always need to remember. The victims and their families. Okay, with that, guys, I will bid you adieu. Thank you very much for being here, and I will see you on the next one. Take care. Thank you very much for watching this video. If you liked what you saw, please consider subscribing. And if you have any questions or comments, please leave them below.